I know this probably goes over the top of most people's heads, and I apologise for that. But it's really actually important when it comes to all these fines. Not only ULEZ fines, but all the speeding fines and the 20 mile an hour fines and pretty much all of them. And I really want to attach this evidence to that Noel's case that he's bringing against TfL. And I want to post this on the group. I don't know who bothers listening to my video. I don't know if anybody can be bothered. It doesn't seem to attract that many replies or interest, but it's important. I'll try to make it not go over the top of people's heads. Try to make it understandable. I mean, on the Verbs channel, if you check out Verbs channel on YouTube, he has quite a lot of interesting guests on, and he's just had a guy on talking about common law and the jury and so forth. So this, I've just worked this out, and I don't think I'm wrong either. And I think this is really, really important. But we know there's loads of illegal signs around and all manner of things that are being done unlawfully. I mean, everyone's calling out, the MPs and the councillors for not telling the truth. So, but there's a lot of errors in the law that I've been finding while I've been learning more and more about the law. Now, it's a little bit like it's the other version. This is like the Scottish version, but it's still applicable. It's like the Bill of Rights, and we're all using the Bill of Rights when we're basically everyone in the group who is engaged with this campaign, the whole action is using the Bill of Rights, and anyone who goes out holding signs and so forth, that's what we're all using. Now, this is the Claim of Right, 1689, which is very similar. What it does is it adds a lot of confirmations and clarity to the Bill of Rights to do with, like, you cannot be imprisoned for engaging in petitioning and so forth. Adds it onto, can't be prosecuted. But this Claim of Right, so there's this really, really important little bit in it here. And it's only one line, right? And you've got to, it's kind of in a little slightly, old-fashioned English, but if you can understand what I'm saying now, you can understand this, even though I don't have a London accent, but that's not my, I don't want that held against me. I'm trying to help everyone out. So it says that forcing the ledgers, that is informations and knowledge, testimony, statements, to depone against themselves, that means to commit, admit crimes or give evidence on offences in capital crimes, right? However, the punishment be restricted is contrary to law. So this is like restricted punishment, reduced punishment. So I truly believe that this is basically, this is the statute underlying foundational provision or law that says that you're not allowed to promise lower, if people, you're not allowed to promise lower punishments for people admitting crimes, obviously, like, effectively, they used to hang people, can you imagine if, so basically, this is the best example I can give, really. If someone's on trial, if they say, look, right, if you, spill the beans, if you admit true, if you tell us everything, and if you dob in all your accomplices or whatever, we will not hang you. Basically, we won't kill you. We'll go easy on you. Which you're not allowed to do that. The sentence is meant to be judged on the merit of the facts and so forth. You can't say, you're already under oath to tell the truth anyway. But by promising that, if you've done a really, really serious crime, but promising that, it will go easy on you. The thing is, if you plead not guilty, you're saying that you're trying to prove that you're not guilty, right? That if you plead not guilty, you're saying that you didn't do it, right? So now, they can't make you plead guilty if you think you're innocent, because you've got the right to plead not guilty. So this is like trying to make, come on, plead guilty, and then we'll go easy on you. They can't coerce you into pleading guilty to go easy on you, right? That's illegal. When I was in court, they were like saying, courtroom 1 is all the guilty cases and courtroom 2 is not guilty cases. And then they were saying, the court that they're having all hearings for not guilty, it's full, it's too busy. They want you to plead guilty and go into the other courtroom. So they were trying to actually they were trying to make me change my plea, which I think that is possibly illegal as well. Also by claiming that it's inconvenient for them, basically, for me to plead not guilty, or that they haven't got the facilities or time to do it, that they can't provide facilities. That's got to be illegal, that's got to be illegal. But getting on to this, so now when you plead guilty, you're already saying that you did it, right? So by entering the plea, right? By entering the plea where you say, I did it, you're saying you're guilty, right? But they can't get you to admit guilt by, like if the punishment in law, for murder is being hanged, they can't say, we're not going to hang you if you plead guilty, because then you won't be getting the punishment where it is. What they're trying to do is they're trying to bargain basically with you. You're not meant to do bargaining. Or they're basically doing you a favour, basically. Or we'll go easy on you, basically. We'll do you a favour. That is favour. So now, the thing is, when you admit, the thing is, if you're pleading not guilty, you are going to prove, or if you've got a lawyer or you do it yourself, you're going to try to put a case forward and prove that you didn't do it, or that you aren't guilty of the offence. Or you can claim a right. If you're claiming a right, like you can't be prosecuted or something like that. Like right to petition immunity or something like that. You're claiming an overriding objective of a right or something. If you're ill halfway through the court, your proceedings get adjourned or whatever, you're exercising the right. Proceedings are adjourned, because the right comes into effect. It's overriding law. Now, so the thing is, let's get this right. If you're trying to prove that you are not guilty, then you're not saying that you did it. Now, if you do plead guilty, you can still do this mitigating circumstances, but the mitigating circumstances is more like the mitigating circumstances. You're admitting that you did it, and you're admitting that. But you're trying to, you have said that you did it, and then you are saying to them, you're saying, please go easy on me. But then you've given all the information. You've given them all the information, and you have admitted it. You've sworn, to tell the truth. But so you've given the information because you've admitted guilt, confessed, and then you give mitigating circumstances to get them to reduce the crime. They're not doing you a favour. You are, basically, you are trying to say that, you shouldn't have that sentence because of, you giving actual reason, right? But the thing is, before pleading guilty or innocent, They can't say, if you give us information or if you admit the truth, we'll reduce the punishment. Do you see what I mean? Because then what they're doing is they are offering you a reward or favour for giving information in on yourself or other people, which forcing on the deponent against themselves, but that is different to, what's just popped into my head now, and I didn't think of this before, is like a reward poster. So like in Robin Hood or whatever, they've got those reward posters up, for Robin Hood or whatever, reward for informations. Have you seen, this thug or whatever? They're offering a reward to witnesses, right? Or the public. They're offering a reward. But that is not to you, the accused. And that's a very important distinction. That is not the accused, right? It's not yourself. They're not offering you a reward for, they're not offering you a £500 reward for dobbing yourself in, and then, it just happens to be enough to pay your fine off, so then you don't have to have a fine. You see what I mean, right? So this is how I can best explain this. I'm quite sure that this is what it is. Now, the thing is, so, you might be thinking, oh, this is like really old, what's that got to do with anything? Well, I think it's this. These are the various oaths that you take if you're like on the jury, or if you're, going up on the stand giving evidence as a witness, or then there's the oaths that justices of the peace or judges have to take. Oaths of allegiance to the king and just general judicial oaths. Now, the thing about oaths is this. The thing about the oaths is that many of us make these oaths whenever you submit anything legal, whenever you fill a form in for the police, or if you're required to give evidence on either side or for whatever reason, or if you're self-representing, if you read all the procedure rules and the law, you'll read that, the professional way to do it, or the proper way for it to be accepted by the court, you have the statement of truths on there, and you write that, you write something in a statement or whatever it is, and you say, I swear that this is the truth to the best of my knowledge, and then you sign it. So when you're entering legal proceedings, or when you're ever representing in law, you've entered you're in the judicial process. And that's important. Even if you're charged with an offence, when you're being charged, it's not only like, being, given a lightning bolt up the ass and, you shit your pants and, this is a big burden to you, a heavy burden. Why call it charged? It's not like you've been struck by lightning and you're in shock. When you've got a battery, you say you charge the battery or putting power into it. When you're being charged with an offence, they're not just like zapping your battery so you're powerless and you aren't competent enough to represent yourself. Because when you're charged with an offence, even though it's a great burden, you are therefore officially you are brought into legal proceedings, and you, as a defendant, you have got a right to defend yourself. And with that right to defend yourself is, what is a defence in, trial by combat? You get given a shield, and, you have a legal shield of defence. So if you were extremely knowledgeable in the law, up to a high degree of processes and procedures, if you're charged with an offence, you could start, if you wanted to flex your muscles, if you had intellectual muscles, you could start, going to the judge, right, I want a subpoena on this information from this, company or witness. I want subpoena on this information from them. I want you to give over this documents, these facts. I want this building searched. There are fingerprints in there that prove that I didn't do it. You see, you're charged to defend yourself. Now, usually the police gather evidence on you and decide to charge you, and then usually you think the police are against you, and then the CPS take over and everyone's against you, unless you get a defence lawyer. But if you are defending yourself, if you're not if you get bail or whatever, like, Lawrence Fox got bail, he shouldn't have even been charged anyway. That's just insanely ridiculous. I don't even know what's going on with that case. It's comedy. It's not even comedy. It's disgraceful. You really can either yourself, while you're out of court, you go get evidence, pull up at the side of the road, measure some road signs, anything that the police can do, you can do to prove your case, unless when the police need a warrant, then you need a warrant, but then you can go to the judge and get a warrant. This is the thing. Do you know how to ask the judge to get a warrant? Do you know what forms to fill in? Do you know how to even, make that, clear in the court and ask for it at what time and so forth, which I'm not very proficient or skilled in court proceedings. I don't really like them, but when I'm comfortable and I read the law and I understand it, and there's procedures and processes and I understand them, and I'm sat here now talking on my phone, I can do it. But I don't like being under pressure at the time, because you don't have necessarily have time to think, or procedures aren't going properly. You're getting challenged by the judge. You're trying to force you to change your plea, or the judges challenge jurors as well, so forth. So this is the thing. So the capacity for defence when you're being charged is actually being given powers. And really, if the truth of the matter is that you didn't do it, but someone else did, or even that the police have done a more serious crime, I mean, the police are allowed to break the law and so forth, But this is the thing, why are we getting charged? Have we got certain powers and so forth, to when the police are kicking people's doors down and damaging things in the line of duty? This is the thing, So, in the line of defending yourself, in the line of duty, you can do things, or whatever the police can do, with or without a warrant, depending on whether you get one or not, And no police officer ever got a warrant for chasing after anyone at 80 mile an hour through a 30 zone in order to apprehend a criminal. No officer got a warrant. He's just using the police that he's pursuing criminals. Because, it would hinder the progress of the vehicle for the purpose for which he's being used. He never got a warrant for it. Doesn't say how fast he can go over the speed limit either. Just says it doesn't have to observe it. So, so this is the thing. Now, so, it's important, when to know that, powers. Now, the thing is, going all the way back now, I forgot why I got into that, because of defending yourself and so forth. Now, the thing is, so what they're not allowed to do is, they're not allowed to get a accused or a defendant and say that, if they plead guilty, they will reduce a punishment. Or if they give information, they will go easy on them and so forth. Because that is a reward, right? And they're forcing ledgers from you, admissions, by promising of favours. And that's what I'm sure that is where it is in that claim of right. Now, in the modern law, it actually, now it says capital crime in that claim of right. It says capital crime, but it means crime. It means not like, like, I'm not sure whether parking tickets qualify because it's small and petty fines. You don't get a criminal record for them, but you can get the bailiffs around there to take things from you. But what I actually believe is that, they got rid of things like, they sort of abolished capital crime in a way, and getting death penalty and so forth. But that principle, it kind of covers serious. The thing with driving offences is when you're facing losing your driving licence, it is quite serious to most people who drive, because your whole life, when you're a driver on the road, you have a certain, it's your livelihood. And in Magna Carta, they can't take the cart off anyone. You're not allowed to take your cart and your access to use your cart off you. They can imprison you or fine you, but they can't take your job off you, your livelihood, your skill, your trade. And if they take your driving licence off you and you forget how to drive, they've actually stolen your skill, your trade from you. It's almost like if you're a blacksmith, they can fine you and they can lock you up. But say if they suddenly put some device on your head and took away all your blacksmith skills from you, so you couldn't actually, you didn't know how to do it, that was like taking your blacksmith skills from you. Now, with driving, the thing about being banned for long periods is you get worse at driving, not better. And the whole point of driving punishments is they want to improve your driving. So what they're actually doing is taking your driving skills from you. They're actually taking your driving skills away from you, removing them, which that is in contravention of Magna Carta, really. Not just your horse and cart, but your ability to use it and the skill of your job, particularly if you're a delivery person. That's why I've never liked it. And there is a defence in modern law, which I believe originates from the Magna Carta, which is that, if your boss is putting heavy schedules on you, if you've got a job that's meant to be 9 till 5, but he's sending you out and you're not getting back till 8 o'clock, he is sending schedules that is actually beyond what he's paid you to do, and he's actually, taking, if he does that, every day for a year, then it's taken away a year of the time it was meant to be for you, So it is almost like, taking away all your free time for you, and it's almost like slavery, really, when you're meant to be back home, but he's sending you on long errands all the time, and you're not getting back. So it's, you're not meant to have your ability for working and transport taken off you, if that's your job, as punishments. Not to say that people shouldn't be fined, but the penalty point system was meant to be, just get penalty points rather than taking it off you. But when all this petty offence, but then suddenly you're in court and you're facing losing your licence, well, but you might have done something less serious than the first time when you only got points. So, they do this totting up. But really, if it was that serious in the first place, why weren't you in court? Well, the reason is that they're doing these conditional offers. They're saying, you don't have to go to court. If you, if you pay this fine, within so many days, it can all be done and dusted and go away. But if you don't pay it within so many days, then the fine's going to go more and more. What they're doing is they actually are offering you a favour. They're doing you a favour. In fact, in saying that you won't even have to go to court. You won't be summoned to court if you just hand some money over, a little fine. You won't have to go through the whole court process. Well, that is a favour. They're offering you a favour there, that you won't be summoned to court and you won't be required to defend yourself in law if you pay over a fine to the police chief in his nice little tidy ticket office. Now, that is a favour. If you admit the offence, admit guilt, or tell them who was driving, give information, right? So now that is against that clause in claim of right, I believe. Now, you might say, well, it says capital crime. Well, it means crime, offences. And I can prove that, I believe, because in this oath. Because this oath this is the oath that all the judges take. And it says that I, and then the name of the judge, do swear by Almighty God that I will well and truly serve our sovereign King Charles III in the office of whatever it is, district judge or justice of the peace or high court judge, and I will do right to all manner of people after the laws and usages of this realm without fear or favour, affection or ill will. So you're not allowed to give or receive favours, right? Which is gifts and rewards and so forth. Now, the thing is, I think that I am absolutely 100% certain. If I'm wrong, I'm wrong, but I don't think that I am. I really don't think I'm wrong on this. I think that in these modern, I think that is that claim of right clause. And I think that that's how it now, where it comes through. And I think that they're not allowed to. They're not allowed to do favours, and it's in the oath. They put it into the oath. It's in the oath. I don't know whether it was in the oath before the claim of right as well, but I think that that is it basically, and because it's in the oath, it applies to all due process of law. All cases, all offences and cases, but not just before the court, all cases that have been investigated by the police, surely, that would go to court. Now, I'd be interested to see what oath the police chief takes when he becomes a constable. It's something along the same lines. There are oaths when you're on the jury, there are oaths when you're giving evidence, but then there are oaths like if you, like I said, if you're ever giving evidence or writing into the government or law, you write the statement of truth at the bottom. Now, this is something very, 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 very interesting. Whenever you give an oath with witnesses, you are charged with, the certain authorities to give evidence, and you have to take the oath in many instances to do it. So when you're writing legal statements, the proper way to do it, to give it legal effect, is to write this is the truth to the best of my knowledge. So I hereby do declare, and then sign your name, right? Now, the interesting thing about when you're doing petitions to the king, when you petition the king, I've written to the Queen before, and if you look, there's meant to be a proper way to write to the Queen, and at the end of it, you say, blah, 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 I will be, your lawful servant, right? That's when you're writing a letter to the Queen. Now, you're making the oath. If you put that on there, if you're not, sticking two fingers up to him or whatever and calling him, a pimpernel or whatever, I will be your obedient servant and so forth. So when you're writing to the Queen or King, the proper way to write to them at the end of the letter, if you do it properly, you don't have to do it properly, if you choose to, is with the oath to them of allegiance. So it gives it legal effect. Now, with the right to petition the King or Queen, therefore, if you write to them and complain about something and do that letter properly, it's actually giving it proper lawful effect, right? And everything you write with, this is the truth. So this is lawful powers coming into effect that you're invoking in letters. Now, obviously, at a later stage, I fell out with the Queen and I told her to go stick it. and that, I'm not going to be a servant anymore. But when I first started my petitioning campaign and I was doing it properly and laying evidence and submitting evidence and starting the case, I did pledge until I realised that they were corrupt and they didn't deserve my allegiance, because I was submitting documents and I was bringing cases to them lawfully, and they weren't doing anything. They weren't complying with the law. They were breaking the law. So because they didn't uphold or respect any of my rights, I thought, well, they're corrupt. I'm complying with this law and they're not. So, sod their law. So, and this is why I have no respect for police chiefs anymore, because they're corrupt. The police chief is corrupt. Sadiq Khan's corrupt. Boris Johnson's corrupt. Rees-Mogg is corrupted. The whole government is corrupt. They are liars. They are, a rum lot is an understatement. They're like, a putrid, like a bad egg gone off. Crack an egg open and there's all, inky, dark liquids in there. So, but another thing. So when you make these oaths, and when there are witnesses to witness you making the oath, in front of the public or whatever, it has an effect. And I remember that, when I used to go to the Cub Scouts, we did this oath, do my duty to God and the Queen, and you have to raise your hand and swear it, and you're doing it in front of the leader, the scout leader. A lot of people from Cubs and Scouts go on to join the army. It's almost like an army for children. You do it in front of the congregation, the public, and you swear the oath. I made that oath. But the thing is with the oath is this, particularly with the Cub Scouts, and that it is your duty to God first and the Queen. God and the Queen. And I didn't think the Queen was being true to God. I don't think the government are being true to God. In fact, they seem to have scrapped religion a lot now. I've got some of these juror statements and affirmations now are actually for Sikhs, Muslims, and so forth. I find it interesting that if you are if you've got an atheist on the panel like Dawkins or someone, and what happens if there was a case of divine intervention or something, or if you're outside an abortion clinic and you're a Catholic, what if the jury are all atheists and they don't have to swear allegiance to God? They're not believers. I'm not saying this is not a religious argument, by the way. This is just like hypothetical. Then you're really up the creek, because if you are doing something that's true to the Christian religion and true to God, but not necessarily in line with the law, and you're a believer in that faith, and you've got a lot of atheists on the panel, or Dawkins, or a lot of Sikhs or something, no disrespect to them, and they make a different oath that isn't to God, then you really are screwed in legal proceedings. This is just one of the examples of how the legal process is being perverted. When the legal system's built up on a particular religion, or at least a particular order, so it creates problems. Now, let's just go back to the oath, right? So a lot of people have taken this oath. For example, if you were in the Cub Scouts, I petitioned the Queen directly with the allegiance and the evidence and so forth, as well as submitting it to the Parliament. So I'm good for that. Even though later there are actual judicial appointments, believe it or not. And I just read this the other day, and this is out of legislation, so I'm not wrong about it. I can't remember exactly which it applies to, but some of them absolutely for certain, and that is that There are judicial appointments which don't require an oath of allegiance. Now, the funny thing is that what I think the petitions committee at the moment, the funny thing with the right to petition is that you aren't held to any commitments. So it's questionable if you have to put they don't require it, the petitions committee, to have an oath of allegiance or a oath of truth on there. Now, if you can't, if the right to petition is not to be held to any commitments, does it mean that, other commitments, but the fact that it's legal proceedings, that you should have commitments to legal proceedings? But other than that, because when the fact is you're petitioning the king, even possibly in grievance, the fact that you're actually sending it to His Majesty's government, officially submitting it and so forth, and informing, this is the thing, the origin of juries is the public informing on crimes. The fact that you're committing something to writing and telling the truth and asking for something to be done is putting a witness statement. Now, if you're going to put something down in writing, and you don't, I would suggest that why would you be opposed to putting a statement of truth on there? Because the last thing that you want to be accused of is being a liar, really, but just for your own pride, your own integrity. So, why wouldn't you want to put a statement of truth on there, even if you didn't have to put one on there? You'd want to. But the petition is meant to be proper legal due proceedings. I think those commitments, I'm sure it's almost like, you can't be charged money for petitioning, or you can't be charged money for elections and so forth. It's funny that we have to pay a fee for legal cases, but usually if you win, though, you get it back, Now, I've spent a hell of a lot of time talking about this, 36 minutes. So what? So what about it all? So what about that, it's got this favour? So what about the favour? So what, Okay, let's say that petition of right says that it's illegal to make people give information or reduce punishments for favours, and let's say that's right, and let's say that, and it's expressed in the all judges, and possibly even police officers have to make that oath when they're made constables and so forth. Let's say that, let's say it is illegal. So what? Well, I think that the whole modern, and we're talking like probably since probably the 90s, the 90s, since they started doing the fast track. I mean, I've got some driving licenses, some specimen driving licenses, those little card ones that open out. I think some of them are 1950s, 1960s. I think my granddad definitely had one. I don't think my mum and dad had one of those ones. So really, in the lifetime of my, my parents, so my granddad will have had these licenses, and you got these. I think they used to just do fines and short bans. They did do fines, like you got a £5 fine or something for not having your license on you, or you got banned for a week or a month or something like that. I do think you might have had to go to court and so forth, but whatever it was, there were specific punishments. But the thing is, we ended up somewhere around the late 60s, early 70s or mid 70s, and then through the 80s and 90s, which is like all within the lifetime of one living person, really. And remember, this is very, very, very old law, going back, to the 1600s and beyond, right? So we're talking about a very recent modern thing. I mean, we've all got smartphones now, but, it wasn't that long ago since we were all on fax machines and, not even having mobile phones. Just like put your finger in the telephone and turn the dial around, and watch, ring, turn your finger around the dial and then it goes, operator, so things that all this is happening very fast. I truly believe now that if they believe you've committed an offence, you've got the right to a fair trial, right? A right to a fair trial to prove that you're innocent. And what they're actually doing now is this. They're wanting you to admit guilt, confess by post, and accept and not have to be summoned to court. You won't be summoned to court if you pay this fine, and you won't even have to enter a defence. So immediately they're doing you a favour there. And particularly, if you pays this fine within 30 days, then it's only going to be £65 or even £100 now. But if you don't pay it within 30 days, then you'll have to pay us £200, and then if not, you'll send the bailiffs around, or you'll have to go to court. Well, if the bailiffs can't come around with a court order because there's due process, you can't have things taken from you without due process of law. Although they removed that from the Petition of Right, which is from Magna Carta, said that it was unnecessary. So apparently, as far as I know, removing that Magna Carta clause from the claim of right, apparently you don't have to go through due process of law for them to repossess your things. They can just do it without due process of law, which makes me wonder not what's going on with them just sending, if you don't pay a fine, and they send the bailiffs around and probably don't even get a court order, because Verbs is saying that, they're down at whatever it is, I don't know whether it's Southampton Court or wherever it was, just stamping, they've got 600 fines to put through and only an hour to do it, and everyone turned up and it was impossible for them to hear them all, and they were trying to talk people to go away. So maybe they were using that little, maybe they made themselves a little secret legal loophole by removing that Magna Carta clause from the Petition of Right. So you don't have to be put through due legal process anymore. Maybe they like on the quiet, which is concerning. But they said it's unnecessary. But it's that's a little bit more of a joke thing, but it's not funny, So, I actually believe. Let's come back to now. I believe that this trying to get confessions out of people by post or give evidence on their partner or their friends who was the driver. You see, if you weren't, this is the thing, like with Noel Gallagher, Noel Gallagher got 6 points, didn't he? Or he might have even lost his license. But Noel Gallagher wasn't driving. I think someone else was driving, but he just didn't reply. He didn't respond, and he got. I think he might have lost his driving license, so he got 6 points on it. But he wasn't the driver. Someone else was driving, but he just didn't reply. He didn't respond to the court. He just ignored it. So he didn't give any informations. So he was found guilty. Now the thing is that they've written into the law that whoever's the owner of the vehicle apparently is responsible or liable for it. But the thing is that if you didn't do the crime, right, why admit that you did? Particularly why admit that you did it and pay a fine and not be summoned to court? Because that's saying that, okay, you're not going to get summoned to court and you're not going to have to defend yourself in law if you, say that you did it. Or if you say that someone else did it, like your next door neighbour's dog was driving or something, we won't summon you to court. They're actually trying to get you to have a favour. We'll do you a favour if you give informations, and that is illegal in the claim of right. This claim of right. It's a Scottish version of the Bill of Rights, but apparently it's applicable. It just helps clarify a lot of things. So I actually believe that it's that there. That is it there. Where is it? It's there. If you're looking for it, what is it? I think that that's it there. I'm absolutely certain that that's it, because it's an unlawful principle institute law. So when you've got an unlawful principle institute law that's in effect, well, where is it? Well, I'm trying to find it. Well, where is it then? Is it in use now? Can we see it? Well, yeah, it's here. Look, it says that it's legal. You're not allowed to judges in judicial process, not allowed to give favours, particularly when it comes to being judged. So, I'm sure that's it. So, it might have even actually originated earlier on than that, but I mean, that's where I first became aware of it a few weeks ago, maybe a month or so ago, and then I just found it in that oath. I'm like, oh, that's it there. I know that's it. That is it. So I and the thing is, when I saw it in that claim of right, there's some really interesting clauses in that law that really help to add clarification to the Bill of Rights. And now that I've found it in that oath, I found where it is. It all makes sense, and it doesn't just apply to these what is called capital crimes, because we don't have death penalty anymore. But it doesn't matter whether it's death penalty. It's just it's a principle which is illegal. It's not lawful. They said that we don't do this. We don't we don't bargain or give favours for evidence and so forth. Not on the accused. Now, if they offering witness appeals or wanted posters, is actually asking the public at large for informations. That's different, because they're not accused of the crime, are they? So they aren't accused of the crime. So I've got a lot of other stuff to go into, but this is important because no matter what illegal road signage you've got, you can argue about road signage all day, but this is a new modern thing that they just started doing. This is good. We're getting lots of fines out of this. They're getting loads and loads of fines out of it, making a load of money. They were getting ahead of themselves. They were really getting ahead of themselves. I don't know if some of them knew that it was legal, but the thing with the government is they really like to do things that they're not allowed to do. They've got this ambition, and it seems to be whenever it says that they're not allowed to do something, as much as any criminal on the street, in the academia world, they seem to like to break that rule or law somehow, or cheat it, loophole it, and still do it. Or, we're not allowed to do this, or we'll show them, we'll do it. They've got this knack, the rum lot in the Lords. Oh, trim down on justices of the peace. They always seem to be seeking that con or that trick. We can do the undoable. It's almost like MPs. Always like Johnson. Basically, Boris Johnson is almost like the mascot of it. Boris Johnson is almost like the embodiment, the hero, the idol, the godly manifestation of this corruption. It's like he's born to break the law. He's born to lie. And this is it. I'm not saying that the entire justice system is all corrupt. I mean, there are some honest, women in there, some, honest characters, but some of them either are not really up to the capacity, or they're a little bit blurry on it, they're not quite clear on it, they don't quite have the capacity, or they don't quite understand it, or they're kind of like, they've got themselves embroiled in it that much through their career that they're in a very sticky situation, like flypaper, like black belt barrister and people like that. They know what's right and wrong, but they've got their hands dirty. It's almost like the speed guns, using the handheld speed guns, the laser slip on the bonnet. It happens all the time, but once they've done a few, then they've done a few too. It's difficult to be a police officer using handheld speed guns without, getting this laser slip and without errors happening. And then there's false evidence being given in courts about the size of the laser beam and so forth. And eventually every police officer has broken the law. So they get to a point where they're that inky. It's like, they get those invisible ink on the bank machines. If you steal a bank machine, then apparently the invisible ink explodes and it goes all over the criminals and you can see it under a UV light. It's almost like that. If you start, all these principles that have been broken and corrupted, once you find out who's involved in it and who's done it, it turns out half the police force. Now, this is when you start getting a peer group of people who are then not going, it's all or nothing, isn't it? It's like, oh, fuck, we're all covered in fucking invisible UV ink because we've all broke the law. So, if one of us goes down, we all go down. So then what you get is this affiliation, this kind of like... you could say it's racketeering. Really, it's racketeering. It's like they're trying to do protesters for those RICO charges in America now, but really half the police force and the courts really need doing for these corrupt engagements. So they all protect each other because they won't do anything about it, and the reason they're protected is because no one we don't have anyone who will prosecute them or take them to court, and they ain't going to do themselves. So that they're protected. It's peer protection, and that is effectively how the House of Lords works. Peer protection. Barons and lords can only be tried by their equals, and if they're all, if the barons and lords are all corrupt and been making legislation and revoking legislation, which really is not compatible, like revoking the Magna Carta, petition of right clauses, which says that we can only be fined or dispossessed through lawful due process, then you don't have to use lawful due process anymore. Why? How is it unnecessary? Because it's necessary, because you might say, well, we've got all these other procedures, yeah, but all those procedures are only enforced by the fact that, you have to, because what if you've got them all, but you don't have to use them, what enforces the fact that you have to use them all? There's a lot of things like the Appeal Jurisdiction Act that Gordon Brown revoked, multiple jurisdiction Appeal Jurisdiction Acts, which, to be honest, aren't really necessary. I mean, you don't really need the criminal procedure rules, because you got the Magistrates Court Act. You can write a witness statement and lay a case to a judge without the criminal procedure rules. There are, there's an established system. There is, the model for petitioning the king. It is bringing a case to the king and he judges it, That's not through the courts, so you can do direct. There's enough in place. Now, this is the thing. This is why they said that petition of right clause was unnecessary, because you've got all this in place, but that's what enforced all that to be compelled them to adhere to it all. Because if you don't have anything to compel them to adhere to it all, then they don't have to do it. Even though if there's procedures, who says that you have to? They must be used, I've added a lot more into this, and I don't really like posting it on this group because I don't really think that many people on this group have got A, the attention span, B, the interest, or C, it's kind of like a little bit more light and fluffy. This and that. Plus, I think that it'd be better if I actually got someone from London to say it all for me, and then it probably would fit a bit more cozy in there. But I actually believe that I'm right about this. I believe that there's a case for this, and it would be a huge case, because then you would be asking a lot of very professional lawyers all over England, hundreds or thousands of traffic lawyers, why they didn't pull them up on it. Why they didn't realise that I've had too many drinks on a weekend, smoked too many cigarettes, Why didn't it suddenly click to them? Well, I would say that it's not required reading to read the claim of right. And I think that unless you are interested in it, I mean, the oaths and so forth aren't really, they don't click on that intellectual level until you actually know what you're looking at. I mean, what is this oath? What is this oath? What does it even mean? What does it even apply to? What am I even doing now? I don't even, and the thing is, if the government, if the government say that it's all right, it must be all right, and so forth. Yeah, a lot of these legal advisors in courts, these, post office women, knitting club women, legal advisors, just come out of university and work for a solicitor, then got a job in a court. Yes, they are knowledgeable in one sense, but not in another sense. They're lacking a certain capacity. And, I don't think that they would challenge certain things like that. I don't know whether it is above their level or not. I'm not sure. And they've got this whole thing where they've got to protect the services which they work for and so forth. But actually what that means is they've got to protect the services from becoming corrupted, from being misused and abused. And this is an example of where I think it is being abused and misused. So I actually believe that this whole, basically, it's called the conditional offer. These conditional offers, it's something that the police chiefs really pushed and liked, but who gave them the idea? Well, I think it all comes down through rank and file. It possibly John Major's government, and the name says it all, possibly Prince Philip. I get this feeling that it's got some military origins in and around, this, where the royal butt joint, the dovetail butt joint meets the police chief inspectorate sort of general area around that, dovetail joint kind of area. That is sort of where it comes from. Secretary of State for Defence and Transport, a Rumlot, Sergeant Stripes. It sort of comes in there. There are some solicitors, Presswich and stuff. There were some books on traffic law, and they had certain advisory and so forth. But whenever it happened, there were mistakes. Now, we've got these committees in government called, in America, they call them the oversight committees. And that would be this type of thing. You have these big government committees very high up called these oversight committees, which is, something went wrong and people kind of like, it went over the top of people's heads when it should have been called out, but it affects a hell of a lot of things. I think that I'm right about this. And I think once it clicks and you understand it, I think you'll agree with that principle in law. When you understand that what they're doing is they're getting you to admit guilt by post, even if you might not have done it. A hell of a lot of people actually don't think they broke the law or weren't speeding, but they're getting a confession and they're paying a fine when they might not have even done it. For without even having to go to court or have a hearing. So I think that it is this, it's against the oath. Now, whether or not there's one thing at this point, this is guess, that there's one guess that I've got, and that guess is that goes on the police chief's oath, and he will have one, because when the there's a difference between PCSOs, community support officers, and actual constables, although we've got powers of arrest and we can use the Criminal Law Act and so forth. Then you say, well, what makes a constable? Well, if a justice of the peace is only made a justice of peace by proper administration of taking the allegiance and oath and so forth, then I'm guessing, this is the only guess in all this, by the way, all the rest wasn't a guess, all the rest is my opinion upon fact and law. When it comes to the police chief, some police chiefs are justices of peace. Chairs of councils, I think some councils are justices of the peace, but they slimmed down on them. There was a hell of a lot more people with justice of the peace power, and the House of Lords wanted to slim down on the number of justices of the peace. I do think that Cub Scout oath has some surprising relevance. Dib, 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 dab, dab, dab. If you're getting a pen in ink, dibbing your pen in parchment, dibbing your feather into the ink pot and writing on paper, Cub Scout code, dib, 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 dab, dab, dab. If you write into the Queen by petition, this is when we're getting then into the whole petitioning the king and the immunities and bringing a case and evidence and it not being through the normal court process and who signed the petition and if you've made a pledge of truth to it and it is with oath to the king, even though you're not meant to be held to by commitments for petitioning the king, what powers have we got? It's almost like, and this is the thing, I've just watched a video with the jury. And I thought, in my mind, I kind of thought that if you get chosen for jury duty, you sort of go into court and then you sort of go into some back room and then some weird clerk with a strange robe comes in with some, and this is comedy now, this part, some satanic dagger or something or whatever, and or some, I don't know, light some candles, and then you all have to sort of like, say some enchantment or something, or maybe one of the judges puts his hand in baptism thing and then puts the sign of the cross on your forehead and then, maybe I baptize you in the name of the Holy Spirit or something. Maybe I'm exaggerating that part a little bit, but that's the only kind of part I'm exaggerating. It turns out that they just go into the courtroom when it's time for them to be called in, and then they literally just stand up and read. The clerk comes over with a bit of paper and they just read it out in front of everyone and swear the oath. Then it's done. Then they can make judgments. But not far off actually when you're a witness and you go up there and you take an oath as well, or even if you're the defendant, the accused, and you have to swear when you give evidence, even if you're the accused, and given to the fact that if you've submitted a witness statement professionally and properly, and your lawyer helped you do it, it definitely has the statement of truth at the bottom of it and gives legal effect to your statement, otherwise that hasn't been submitted properly. So, coming to the right to petition and drawing up the document and what will you write on there, the ironic thing with the petitions committee is that they don't, it's like a baby form. They don't have any of these things on there, which they could include on there, but then they say that, you're giving flimsy evidence, the links you put, they're libelous or, false or whatever. Well, just do it. Well, I put a statement of truth. I put a statement of truth on this petition. So you put libelous or false links on what you're talking about. This is my evidence. This is my statement. This is my statement of truth. No one else, there is no fact or no fact to my statement. It's like if you petition the petitions committee, right, and not on something from their website or something known in the dictionary or, the laws of gravity, it's known factually. You can't say, well, there is no law of gravity, or it's a libelous statement. No, like, this is like, on Tuesday evening, I saw Mrs. Johnson walk down the road with a yellow jacket on, right? I am the only person who saw it other than her, right? I put that on there, send it to the Parliament Commission Petitions Committee. Oh, this is false or libelous information. What do you mean it's false or libel information? I am the only person who saw it. How do you know? How do you know what it is? That's why I'm writing it down on there and submitting it. you know. And this is why that I think that it's almost like the committee, the petitions committee members, they're all sort of, even though they like to have people like Martin Day MP on there and some SNP and independent ministers on that committee, they're ill-guided. It's almost like if you don't submit petitions that the Tories like or Labour like, they don't want to publish them. It's almost like they want you to swear allegiance to their political party, the Tory party or Labour. If you're running and submitting petitions, something that they like, we like this petition. It's not harming to the government's image. But then again, this is what Robert F. Kennedy's calling them out on. He says that, the Biden and American government and YouTube and Facebook created a new term, malinformation, information that wasn't necessarily wrong or false, just it didn't make the government look good. You can't have that, because we're not here to make the government look good or not. We're here to get certain things done that we want doing, not whether they like it or not. But then again, they've got all these new laws they're pushing through, like, you can't say this, you can't say that, you can't look at someone funny, you can't look at someone with your left eye closed or your right eye closed, but yeah, they're allowed to, might upset someone. If anyone in this bus station makes you feel uncomfortable, go report them. But then again, they're banging 20 houses next to your house, which literally depresses you for the rest of your life. And every time you open your curtains, you're singing out the window, looking over the hills and valleys, there's a big block of flats there. Or a fucking building site for 6 months, and it ends up putting you in depression. But yet Keir Starmer's not running down the road, your champion. Oh, here comes Keir Starmer, the human rights lawyer, to the rescue. Oh, you've been wronged, greatly wronged. You've been wronged. What can we do to put this right? Well, I did object to the building with a perfectly good objection, namely, I don't want it there, but this all the pain that is putting me through, the stress. But then again, someone walked down through a bus station and looked at someone funny, and then the whole, fucking police force turns up, takes them away for harassment, because they, chucked a cigarette on the floor, a pigeon or something or whatever, this is it. So, this is like 1 hour and 6 minutes now. I've gone really, really, really over time. I just wanted to basically say that, essentially, I don't think that those conditional offers are lawful. I think they've crossed the line. I think they've gone into this. I think that they're effectively trying to coerce you into admitting something that you didn't do and that you aren't guilty of for a reduced punishment. And without the threat of having to go to court. And I think that it's against the judge's oath. And even if the police chief gave them the offer, but who's processing it? On whose authority are they processing them, with judges or police chief? What is the police chief's oath? The police chief's oath, if he's processing fines or offences where if you admit the offence as a conditional offer, you're suffering legal consequences for offences. It is an offence. Whenever there's an offence, the thing with parking fines is that it's not a crime. I know that they're fining you for the driving offence, but it is actually a criminal offence. And this is, I think, what makes it illegal, because it is a crime. And I know that in that petition of right it says capital crime, but they got rid of the death penalty, and it means criminal offences. And that is why it's in this oath, because it deals with criminal offences. So therefore, when it comes to speeding fines, when you can potentially lose your driving licence, and even if you weren't even the driver, or, getting someone to, give information on their partner or someone for a reduced fine, reduced fine, or without having to suffer being summoned to court, that it is illegal. And that is a very, very big thing, I think, because what's happened is it's a perversion of the course of justice. And a hell of a lot of lawyers have been engaging in it. And people like Nick Freeman, Mr. Loophole, he should have known that. I don't necessarily think that he would have been focused on that. You know, it maybe he didn't know, but I just think that it's not something that some of them will have clocked it. And even if they did, they'd all been aiding and abetting it and carrying it on. But then again, Freeman's been calling them out on the road signs, but this is more serious than the road signs in the first place. That's where I am with it at the moment. I'd like to attach this video to that Noel's case that he's bringing, because he's getting some money together to do some legal cases. I'm not trying to say that, I'm not trying to overshadow him in any way, but, I'm just a person with something else to add in, I just want to, add some more things in to the rest of the things. We're all meant to be contributing to it. So this is just my contribution. I'm not trying to. I just want to help people out and get the legal system straight, because I don't think that it's been run honestly. Some people know about it. I think some of the Lords, maybe some MPs, but this is the thing. We're getting more and more MPs who really don't have the capacity for the job, or they're being misled. And then you've got, Sunak and Patel knocking out all this legislation to do with rights, which is not enforceable, really. And then you've got them the World Health Organization attempting to take our rights away from us. Override it, when there's a pandemic, when they can't do that because of the Petition of Right. The 1700 Act of Settlement. The 1700 Act of Settlement, the final paragraph says that they're not allowed to give up our rights to foreign organisations or entities or countries, and they're not even allowed themselves to. And they're definitely not allowed to stand by and let a foreign entity do it. It's got to be included in there. The World Health Organization, United Nations, didn't have a choice whether to include it or not include it. It had to be included in there. They didn't have an option, so they can't remove it because they had, they didn't have an option whether to include it or not in the first place. So there's quite a few things there. I don't know where we're going to go with this, because I don't have any money for legal cases. So I just put it all through complaints. I just put everything through complaints processes, because there is a perversion of the course of justice. This actually, I've submitted so many separate things now to the Judicial Office of Investigations. This is actually perverting the course of justice due legal process, but also this is like a breach of the oath. This is the breach of the oath of the judges. And possibly, I'll have to look at the police chief's oath when you get, but it's only a constable. I think it's just a constable oath, but that's the one thing. As I'm recording this video, that's the one thing that I'm not, that I don't know at this time what I probably could do with knowing, but I still think that it goes on to the judges, because someone, I don't know if the police chief signs these. Something odd happened when I had to go to court in Manchester, and I had to do with Sir Peter Fahey, and because I put a newspaper advert in a petition comedy Peter Fahey joke, and it's just, I don't even know what it was anymore because it disappeared from my computer, and I don't have a copy of the newspaper. I'd like to get a copy of that newspaper if I can find it. I'm pretty sure it's October. I'm pretty sure it might be the 1st, 2nd, 3rd or 4th of October 2015, Manchester Evening News. I'd like to see if it was published or not, or if they just planted a copy somewhere. I don't know, but it's the newspaper don't have any well, they wouldn't get me the records of it anyway. So, but when I went to court around that time, one of the magistrates looked like Fahy, so I think it was him. It might not have been, but I'm quite certain it was him. Just like turned up to to be the head judge when as some sort of like prank back because of the newspaper advert that I put dissing him. So it was a bit of a mind bender, but that's the sort of thing they do to you, stuff like that as well. I think I've never, I've seen photos of him, and he looked very, very similar. And I know that police chief might be able to sit as a justice of the peace, or they can take the oath like a chairman of the council. I know they can do it. Chairman of some councils are justices of the peace, so they have got the power to do it. But so well, we have. We have. If you make the thing is, if you set into writing what you're doing on paper, and people, the public make a judgment, a decision, and so forth. This is what the power of the petition to the king is really, particularly if you're investigating something on behalf of the public making an inquiry, and you want an investigation from the government or the king. This is when the minister can initiate an official public inquiry. You're meant to have that right anyway, without having to go to the lower courts. So, if there's evidence of public concern, so I don't even know whether I want to put this on the group, because I don't know if people can hold people's attention. They kind of like more funny, laughy, jokey posts. It might be a bit too much over the top of their heads, or a bit too out there. But at least I've made the statement.